Prosecutor Billy Dower argues that Jacob Zuma's current corruption trial appeal is legally moot and that it is in the public interest for it to be rejected so the former president can face charges. Dower argues in documents filed Wednesday in the KwaZulu-Natal High Court in Pietermaritzburg that Zuma should be denied permission to appeal the rejection of his so-called special plea in which Zuma requested Dower's removal as prosecutor and consequent acquittal on corruption allegations. Zuma is accused of receiving 500,000 rand per year payment from French weapons manufacturer TELS in return for political cover from any probe into the contentious multi-billion rand arms agreement. His special plea was the latest in a long series of instances in which the former head of state attempted to undermine the prosecution's case against him without actually going to trial. Koyen rejected each of Zuma's 14 allegations of prejudice and misconduct against Dower in October, ruling that they were hypothetical, based on hearsay evidence, or not substantial enough to justify Dower's dismissal. Zuma is now appealing that judgment, having charged Dower with breaking the NPA Act by disclosing court documents to News 24. He continues to argue that foreign spies meddled in his prosecution and that the evidence against him has been irreversibly damaged by political motives and suspected misbehavior. Zuma, on the other hand, has no right to appeal Koyen's denial of his special plea to a full bench or the Supreme Court of Appeal prior to his possible conviction and punishment, according to Dower. Zuma, he claims, has also failed to state the legal provision upon which the motion is based. This is unsurprising given that after the beginning of the Superior Courts Act 10 of 2013, on 23 August 2013, an accused in a criminal trial in the High Court may not apply to the High Court for permission to appeal until convicted and sentenced. Dower continues by arguing that the Criminal Procedure Act offers no provision for an accused to seek permission to appeal against the rejection of a plea according to Section 106 prior to conviction and sentence. Zuma unsuccessfully argued under Section 106 of the Criminal Procedure Act that Dower lacked the authority to prosecute him due to his alleged prejudice and lack of impartiality. While Zuma maintained that Dower's allegations bias would violate his right to a fair trial, Koyen finally determined that any breach of Mr. Zuma's fair trial rights, which is the actual foundation of his concerns, is best decided when the evidence in the criminal trial has been heard, digested in the light of contradictory evidence, and the evidence reliability correctly appraised. Whether an accused person will eventually get a fair trial is a question that must be addressed on the basis of all available information. It is perhaps most properly resolved after the conclusion of the trial, but this is entirely up to the trial court's discretion. Exclusive delay. In other terms, Koyen emphasized Zuma might assert his right to a fair trial at his trial, as well as during any subsequent appeal procedure. Dower argues in favor of such position. He believes that the accusations against Zuma and TELS have already been delayed unreasonably and that additional delay would jeopardize the interest of the general public, represented by the state, in having the prosecution and defense arguments fully heard as soon as practicable. He also stated that any delays in the case would jeopardize TEL's ability to have its trial begin and end without excessive delay. Additionally, Dower argues that permitting Zuma to appeal at this point in his trial would not be in the interest of justice, as the interest of justice necessitates that this issue go to trial in light of the two accused not guilty pleas. The prosecutor, who has spent nearly 2 decades attempting to prosecute Zuma, argues that his special plea is the latest in a long line of preliminary cases brought by both parties that have obstructed and delayed the start of the process. Additionally, he says that Zuma has little chance of successfully appealing Cohen's verdict. I respectfully submit that there is no prospect of any appellate court concluding on the papers that any of his honorable court's findings regarding Zuma complaints were incorrect, let alone that I have demonstrated a lack of independence and objectivity sufficient to justify the conclusion that Zuma will not receive a fair trial in any prosecution directed by me. Zuma's bid for permission to appeal is anticipated to be heard in late January.